What we have found through representing parties in these type cases is that if a child is conceived during the marriage, quite often through artificial insemination, it is the child of both parents, both parties in the marriage. And when a divorce takes place, the court recognizes the rights of both parties as if they conceived that child. If an adoption has taken place, generally both parties have adopted the child. If an adoption had taken place and only one of the parties adopted the child, that puts a whole different outlook to it. The party that did not adopt the child may not have rights. You have to look in the facts and circumstances of the case. There's a little known law called virtual adoption. Very few people understand this or even know it exists. But a virtual adoption is where a person who is not the biological parent of a child and has not adopted the child acts and participates in the child's life as if they were a parent. And the court can, based on case law, determine that there has been a virtual adoption of that child and establish parental rights. These are very rare circumstances. We have dealt with them. There are cases where a child may be conceived during a marriage between two same-sex people, but there's a third-party father, usually, that's not a party to the marriage, making claims in regard to that child. The courts have to look at what's in the child's best interest in determining those claims. It gets very complicated, and every case has to be weighed upon all the facts and circumstances of that case. The court's going to look at what's in the child's best interest. They're going to try to apply the parental rights doctrine. Some judges are going to apply those doctrines one way and some another. There is just not a lot of case law out there in regard to this subject. So it's important you have an attorney that understands the subject matter, that can develop the facts, all the circumstances, and present them to the court in the light that best supports your position in the case.